very fortunate to have with us today Professor Nicole Roughan from the University of Auckland, a former member of the NUS faculty. So we're delighted to have her back. And she is going to speak to us today about escaping precedent. It's good for a glance.
Thanks, Andrew. Thank you all for having me again. It's probably the only good reason to leave Singapore, right, is that you get to come back and do this this event.
We don't invite everybody.
Well.
No.
And only once, I think, right? So this will be my only shot. So the paper I'm going to talk to you about is just it's a slice of work that sits between two projects that are ongoing. So I want to very briefly just situate it in relation to these other projects, and then talk about this narrow slice that I take to be quite a small, somewhat technical point of overlap between the projects. So at the moment I'm working on a couple of large-scale projects. One of them is looking at the idea of plurality of laws and interlegality in relationships between legal orders. So it's a pluralistic project, but one that doesn't necessarily endorse pluralism. I'm interested in the way in which interactions of legal orders, including interactions between state, international, transnational, and non-state legal orders, affect questions in jurisprudence. My rough sort of claims and the sort of large-scale claims in that project are about the ways in which interactions of legal orders and overlaps of legal orders make all the problems of jurisprudence harder and more interesting. And it's, so questions about what is law, questions about whether there are obligations to obey the law, and some of the questions that are at times treated as old-fashioned or tired questions of general jurisprudence become quite urgent when given a pluralist bent. That project started as a really intensely theoretical project, a project about jurisprudence, and then has morphed sort of involuntarily into a project which really is about legal practice. It's still jurisprudential, but it has had to accommodate and respond to the ways in which legal practice in New Zealand, particularly, are having to confront these questions about relationships between legal orders in quite an urgent fashion. So the concrete part of that research project looks at the relationship between state law and tikanga Maori, which is Maori law, Indigenous law in New Zealand. And in looking at those relationships, it is really responding to what the courts in practice are having to grapple with on a, I would say, almost daily basis. So I left Singapore at the end of 2017 with a few cases, a handful of, quite significant but small number of cases where the courts were indeed grappling with the question of whether or not and then how the relationship between state law and tikanga Māori could be applied in practice. So can the common law recognise Indigenous law? What does it mean when a statute seems to give effect to Indigenous law? And then critically, what does it mean for the Indigenous legal order when such recognition or such application takes place in the state court? So all those questions were coming up in New Zealand legal practice, but relatively infrequently. Since 2018, when I went back to New Zealand, it has exponentially increased. The number of these cases has increased. So it's a very live question for the courts who are still grappling with how to make sense of this relationship and what is the role of the courts and indeed the law in managing a relationship or giving effect to a relationship between legal orders. So that's the plurality project. On the other side of this paper is another long-term project on the idea of the legal official. And the work on the idea of the legal official, or the official of law, is really an attempt to understand the significance of the idea of the official and the relationship between the role of the official and the role of the subject in questions about law's normativity and questions about the authority of law. So that project takes me quite quickly and quite directly into debates about rules of recognition, for one, but also into debates about the more normatively laden conceptions of the relationship between the official and the subject. And so there are people in the room, Alon, of course, most prominently, who've done a considerable amount of work on these sorts of questions. So questions about representation, questions about standing, and questions about reciprocity, I think are well represented in the jurisprudence world. And my own, if you like, contribution, which I think is an addition rather than necessarily an amendment to some of those other positions, is to look centrally and directly at the idea of recognition itself. So I'm interested in theories of recognition and what they mean for how we understand the idea of the official and its relationship to the subject. Arguably, recognition becomes a sort of a fundamental pivot through which we can identify both, through which we can examine both the idea of, both the role of the official and the relationship it has to the law. So I'm not going to talk about recognition per se today, but it's the recognition hook that I think takes me into this project. Okay, so that's just a little bit of background. This particular project, however, is about precedent, which is not a topic I've written on before, but was provoked to do so by this challenge, this practical challenge that the courts of New Zealand are currently engaged in, which is this effort to really work out and give effect to some form of relationship between the legal orders, contesting, of course, what that relationship can and should be. So what I'm going to do, I'm going to speak a little bit about the relationship between precedent and rules of recognition, as I see it in this paper, and then turn to what I see as this really provocative impact that the interaction of legal orders, specifically the interaction of state law and Te Pānga Maori, has for the way we understand the role of recognition. And precedent's role effectively comes in as a provocation, in some cases a block, and in some cases a signal or a sort of an impact, or rather an intervention in what might otherwise be a customary evolutionary practice of change in our rules of recognition. So there are a couple of things I want to just carve out. One is that we might get to this later in questions, it'd be great if we do, but I'm going to carve out questions about whether or not Te Pānga Maori is law. Okay, for now I'm just going to speak as if that's agreed for the purposes of the paper. Of course it's not agreed, it's a jurisprudentially important question, and it's a practically important question. Right? But I'm not going to talk about the what is law aspect of that question for now. And then the second sort of carve out or sort of concession a little bit is that this is a paper about rules of recognition, and so it requires a little bit of a leap for me actually, because I'm not a big rule of recognition person. I'm somewhat sceptical about how much weight rules of recognition can bear. I think that there are rules of recognition, but I don't see rules of recognition as having the normative significance for understanding law and legal systems as some other scholars do. In the Officials project, I do a bit of work on that directly, which is looking at how there is normativity in the rule of recognition, but its role in the normativity of law depends upon the way we understand the role of the official and its relation to the role of the subject. So I want to just for now say, I'm running with the idea of the rule of recognition for this purpose, and we can hopefully, talk about that later. But I want to park that for now. So, what does all this have to do with precedent? I guess is where I want to start. Or how does precedent figure amidst these bigger projects where I'm trying to sort of slice through the middle with a narrower claim? What I argue here is that that precedent has several impacts on the way in which our courts are effectively managing this relationship with interlegality. On the one hand, you have precedent as a sort of a doctrinal, there is a doctrinal precedent, right, which, as we know, both constrains and empowers, as Grant has put it in his work, both constrains and empowers the courts. We also then have a practice of precedent, which, following Grant's paper from yesterday, we might be more precise about and try and characterise in a number of ways as a kind of customary rule, right? So in the paper, I've just referred to it fairly loosely as a practice of precedent, because I want to argue that that practice of precedent, which is a normative practice, is an aspect of the system's rule of recognition. So you have on the one hand a doctrine of precedent, which overlays an authoritative rule which says courts must, follow earlier/higher authority depending on the exact specific content of the doctrine, and that's overlain upon a practice of precedent, which is a customary practice, which operates within and as an important part of a system's rule of recognition. That is a system which adopts this practice. It doesn't have to be. I think there can be systems without a practice of precedent, but in the common law settler states that I'm looking at, and certainly in the New Zealand example, there is a practice of precedent. There are some finer points to argue about what kind of customary rule this is. Is it customary law in foro, as Grant had argued? Is it a customary social, is it a customary norm but not a legal norm, and so on. But there's a footnote, I think, which flags this debate, but again, that might be something to get into later, because it does actually become important, I think, for my argument. And but as we know, and as most people know better than I, because I'm not as much a lawyer as some others who work in this field, precedents can be avoided. Right? There are ways of within the rules of precedent itself. There are typically defined ways, or at least accepted, recognised ways of avoiding an individual precedent. Right? So the doctrine of precedent determines how individual cases are treated as precedent or have precedential effect, but also determines how you can avoid that, how particular cases can be avoided. And what I argue in the paper is that there are, in addition to ways of avoiding precedent, there is a way of escaping precedent, which is to say that when there are precedents that speak either directly or indirectly to the content of the rule of recognition or to the content of rules of recognition, then reflecting and deliberately being confronted with the question of what the sources of law are, or what is captured by a rule of recognition, can generate ways in which the court escapes precedent by effectively changing the rule of recognition. So that's roughly the sort of first core part, first core claim of the paper, which is that there is such a thing as an escape from precedent, which rather than avoiding the doctrine of precedent, escapes the practice of precedent altogether. And it does so by provoking a shift, or at least provoking a deliberate reflection and a potential shift in the rule of recognition. And you can imagine that this is most obviously the case when you have cases that directly are about the rule of recognition itself. And so the interlegality cases, the cases where you've got arguments about whether or not tikanga Maori or Maori law, or indeed indigenous legal order, perhaps another system, are to be given effect as law, that effectively is a question about rule of recognition, a direct question about the rule of recognition. But there are also, I think, indirect questions, confrontations with the content of the rule of recognition, wherever you have cases that have been decided on the basis of sources of law, which function as precedents, but they function as precedents only in respect of the particular content of the rule of recognition as it was at the time the case was decided. And as rules of recognition can develop as a sort of an undercurrent going along underneath the doctrinal development of the law, you can have precedents, individual precedents, decided on the basis of earlier rules of recognition that no longer are supported by current or even emerging rules of recognition. So that the story of change and continuity in the rule of recognition can undercut, not necessarily undermine, but can undercut the way in which the doctrine of precedent requires that courts apply individual precedents. And when that happens, I say there can be an avenue of escape from precedent, because when the courts are forced directly or indirectly to confront and effectively express content of a rule of recognition or part of the content of a rule of recognition, then they are able to, in some cases, escape precedent. Now, I'm going to do two things with that argument. I'm going to talk a little bit more in a minute about the example from New Zealand that I illustrated in the paper. But I also want to say something first about what this means for a particular debate in jurisprudence circles, I suppose, about how we understand the rule of recognition itself. And specifically, the idea is that a number of people, and really since Hart, there is, I think, a sort of a sub-industry of work and quite a number of people who have written about and argued about the normative character of the rule of recognition itself. So some people reject that it's a norm at all, right? But those who consider it to have some normative characteristic argue about whether it's a conventional rule, as Hart eventually seemed to understand it. But even in Hart's own account, there was a number of places where Hart describes it as a customary rule. And so this sub-industry of work has tried to capture what could possibly make a rule of recognition normative, both in order to ground Hart's own account, but also in order to understand what it is that officials are doing when they see themselves as bound by the content of a rule of recognition, at the same time as engaging in practices that contribute to making that rule of recognition. And there's a fairly widespread, we shouldn't say it's widespread, but there's a very well argued and important body of work which treats the rule of recognition's normativity to be a customary normativity rather than conventional. And where that I think is strong is that it builds in this effectively this role of the internal point of view, right? That is that it's those who are let's just call them officials for now. Officials of law seeing themselves as bound to treat certain things as law and certain things as not law, which is an oversimplification. Of course, there's complex points to intervene here about how the rule of recognition speaks to the sources of law, how it speaks to secondary rules, and so on. But setting that aside for more technical discussion, which we might have, but we hopefully won't. But if we do, and obviously I welcome it, but as a customary norm, the rule of recognition captures also this dynamic of change. And I think both the sort of capturing change as well as speaking to the internal element of the rule of recognition's normativity are important things that we get from thinking about the rule of recognition as a customary norm. However, those who have advocated the customary conception of rule of recognition, in particular John Gardner's work, have also elaborated that when we think about customary rule of recognition, we are somewhat committed to the idea that it's changed primarily by accident, or at least not intentionally, and that it's changed mainly through officials thinking they are following the norm, occasionally being mistaken, but those occasional mistakes then contributing to the new content of the norm. And so this I call the accidental conception of change in the rule of recognition. It is accompanied, I should add, by an additional way in which rule of recognition can get changed, which is the deliberate misleading, right? When an official gives effect to and expresses the content of a rule of recognition which is misleading and deliberately and willfully trying to misrepresent what the rule is now in order to change its content. The other interesting and important factor about the accidental conception of the rule of recognition is that it indicates that an individual official, whether that's a judge or other official of law, can have can have an impact on the change in the content of the rule of recognition as a member of this community of officials whose rule it is and whose practices shape its content. So the individual person can make that impact, the individual judge or other official can have that impact, but that's also quite unusual, right? But what we're actually looking at is a rule of a community, in this case a community of officials. And I'm going to challenge the accidental conception in the following way, and I think this is provoked by what happens when you have precedents that are speaking directly or indirectly about the content of the rule of recognition in the way I described earlier. And it happens most directly in the illustration that I offer here, when you have cases claiming that the applicable law is Indigenous law in a way that conflicts with applicable state law. So the first problem with the accidental conception of custom as it's explained here is that, actually, you know what, I'm going to give you the illustration first, and then I'm going to come back to talk about how the New Zealand illustration, I think, upsets or shows that we might want to reconceive our accidental conception of custom. How much time? I forgot when we started. 15. Oh, good, right. Okay, so I'll give you a very brief, abbreviated narrative that pulls out shifting rules of recognition in the New Zealand context since interlegality, or this interaction of legal orders, was first given effect by the arrival of English law in New Zealand. And this is not a historically rich account. So I have spoken about this work a little bit with legal historians, who, of course, have a lot more context to add, and there are points of disagreement here about exactly how I am diagnosing shifts in what is ultimately a normative social practice. To even recognise or to even comment about who are the officials of law, right, in these different eras and different historical periods that the story is about, is itself an interesting and rich sort of question that invokes legal history. So I want to apologise to those who have more rich historical instincts and knowledge about this particular case. So, roughly speaking, the legal order and perhaps legal orders, or really pluralistically characterised, that existed prior to the arrival of English law were, of course, the laws of particular tribes in different areas of New Zealand, and already rich in their own overlaps and ways of accommodating one another. With the arrival of English law, as was proper according to colonial law and policy at the time, and indeed international law doctrines about what happens to Indigenous law upon colonisation, initially recognised those laws, perhaps pragmatically as well as a matter of principle. And so various institutional mechanisms, as well as sort of practically, pragmatically driven arrangements meant that there was recognition by common law, nascent as it was, and within the institutions, nascent as they were, the state institutions, nascent as they were, of Indigenous law. That then shifted, and I should say, in the broader colonial context, there was also, of course, significant Privy Council authority on this question about how Indigenous legalities ought to be recognised and given effect, and indeed, in some cases, respected and protected. So this was not a legal black hole. There's plenty of law on this question at the time. However, in the sort of great bad guy case of New Zealand jurisprudence, we Parata and Bishop of Wellington, I've just forgotten what year that is, so it's not ingrained in my brain, 1877, and we Parata and Bishop of Wellington, the court, I'm not going to go into the factual scenario, but in very robust terms said that there was no pre-existing Maori law to recognise, and that Maori were not politically organised and legally institutionally structured sufficiently to have systems of law. It also regarded that, this is a side point, but the case also regarded that the Treaty of Waitangi, which had recognised, at least in dominant understandings of the relationship between the different competing texts of the treaty, had recognised the continuation of Māori law, either as an aspect of an important and ongoing regulator of Māori property and interests and rights and duties, or as an aspect of the recognition of Māori sovereignty, which the Māori text of the treaty did protect. So the case, in the way that I'm interested in it, though, is most significant for what it does to the rule of recognition. So prior to the case, although with a fairly rough around the edges sort of content, looking at the official practice, not just in the courts, but also in the way that that policies had been executed, there was recognition of Māori law as law. Following the case, which failed to recognise and failed to apply a Privy Council precedent for reasons that are contested. In some cases, there are questions about how much of the precedent the court actually even knew about, and certain delays in reporting and recording of some of the Privy Council work may have affected that. But regardless, it was regarded later on as having, it was described as having been really revolutionary. Right? At that time, it was a revolutionary thing for the court to suddenly fail to recognise Māori law. The Privy Council very shortly afterwards heard a case where they described this decision in very robust, they criticised this decision very robustly, and also noted that it was rather late in the day for the court now to fail to recognise Māori law. So this is one of those direct cases, a case that confronts the rule of recognition directly. That case, criticised though it was, criticised though it now is, stood for a long time. However, it's not. It was given. It took on a life beyond just the formal operation of precedent, insofar as it became part of a wider official practice and wider official trajectory of denial of the status of law to tikanga Māori. So, following the parata and various other moves around official practice at the time, and really up on into the 20th century as far as the 1960s, official practice was pretty much towing this line. And you could point to a rule of recognition, and I do point to a rule of recognition that says Māori law doesn't exist, right? That there are Māori customary practices, there are customs and so on. But of course, this is occurring simultaneously with actual deliberate state efforts to suppress even those practices, those identities, to suppress Māori language and really to absorb and assimilate Māori persons and values, rights and beliefs into the growing, expanding state institutions and public sphere. There is a lot more to be said about the particular Parata case and what happened afterwards and how it affected the relationship between the courts and the Privy Council, but I won't speak to that now. We might come back to that. What happened subsequently, really quite a lot later, 80 odd years later, was a case revisiting whether or not Parata and its sort of view that Māori law was not law was still, was indeed still a contemporary position. So in the 60s, and then continuing really until, this position was reaffirmed in the 60s in the 90 Mile Beach case. And then it wasn't until 2003 that the court took a very direct look at the precedents. So the existence of the Waiparata precedent had a continuing effect, and then the existence of the 90 Mile Beach precedent had effectively an affirming effect of the content of the rule of recognition as regards this question of interlegality, as regards the question of whether there is an interaction of legal orders here, or whether it's just that there's common law, and then there are little pockets of Māori custom that might be recognised by the common law. In 2003, the court scrapped that position. So in the case of Ngāti Apa and Attorney General, the court considered in very critical terms that the Waiparata approach back in the 1870s, as I said, had been revolutionary, was not supported, and in fact failed to follow Privy Council precedent, as well as the 90 Mile Beach decision, which they were also highly critical of, in part for its following of the earlier mistaken precedent. And there's a huge amount of literature on this about the sort of precedential value of the earlier cases and the way in which the court treated the precedents themselves, which I'm not talking about. Instead, what I want to point to is that the way in which the court avoided the 90 Mile Beach precedent amounted to an escape from precedent itself through a shift in the rule of recognition, which indicated that Māori law could be recognised as law. Now, this is not the end of the story, because, of course, as we all know, rules of recognition aren't made by judges alone, and judges are not the only officials whose practices count towards generating the content and indeed changing and shifting the content of rules of recognition. So the legislature has been involved at various points throughout, and after the court in 2003 decided that it was possible to recognise Māori customary law as law, tikanga Māori as law, faced in legislative interventions about the precise impact of doing that. Right? Effectively, the legislature making it very clear that even if tikanga Māori was law, it could still be overridden by statute. But what happened then is the legislative interventions that followed gradually set up a new regime for contesting claims on the basis of the applicable Māori law, which has generated this exponential development and number of cases, bringing claims which are claims based on the content of tikanga Māori as an independent legal order, based on the authority of Indigenous law, not just trying to fit Indigenous law under a common law test for recognition. And that's a really significant difference, because it means that what we're talking about is not the question of how the common law might recognise particular rights or particular duties, or indeed how the common law might tolerate particular practices, as we talked about on Wednesday, but how it can actually, how the common law can interact with a legal order with independent authority. I talk in the paper very briefly about some, in the briefest terms, about some of the most significant recent cases where this question has come up, because the courts really are still grappling with it. But it is happening with such regularity now that this paper is already out of date. Right? And it was finished in May, I believe. So it's already out of date. Newer cases are finding new ways of formulating relationships, as well as in some cases the court's taking the view that actually their role is not to pronounce on the relationship itself and trying to effectively extricate themselves from the question of how state legality relates to Indigenous legality. And every time they do that, they are expressing content that starts to build up content towards shifting a rule of recognition. So I'm going to stop on the how many minutes? 5. Okay. So that's the interlegality illustration. But what I want to just return to and conclude with is what that means for how we understand the rule of recognition as a customary rule. So what you see in these cases is that when there are precedents that require the courts to treat an interlegality arrangement in a certain way, or to take a particular position on interlegality, and you have continuing pressures and continuing claims being brought that assert or claim to be governed, if you like, under Indigenous legality, then the court is being constantly and very regularly required to reflect deliberately on the content of the rule of recognition. And that starts to look far from accidental, right? And it looks far from accidental because it is this self-reflective as well as reflection on the broader practice around you, which is precisely what the accidental conception is supposed to minimise. So the accidental conception doesn't say this never happens, but it says that a rule of recognition mainly changes by accident. Whereas what we are seeing in New Zealand now is that it is moving, let's say shifting, quite deliberatively. I'm not going to say deliberately, but deliberatively. So the courts are engaged in live questions about what the content of the rule of recognition is. The second factor, which I think is important, the second implication, is that you see that the change in the customary rule of recognition is occurring in such a way that you can't say that these judges, or indeed other officials, not just judges, but other officials too, are misleading or are being deliberately sneaky about the content of the rule of recognition. Because when you're talking about a customary rule, the difference between diagnosing that you're applying an existing rule or an old rule or an emerging rule is indeterminate. So to say that the courts, in cases where they are trying to, or indeed are saying that Maori law is an independent legal order, are not deliberately representing the rule of recognition, are not deliberately misrepresenting an old rule of recognition, even when they reflect on its difference from what a rule of recognition may once have been. So the judges may well be looking around themselves and seeing themselves going with what they take to be an emerging trend or an emerging content in rule of recognition by which they are bound. And the idea is that this is not any, this is a reflective, deliberative engagement that they are having with the content of the rule of recognition. More broadly, it doesn't seem that you can draw a tight line around the difference between continuing an old rule and developing a new one. And this, I think, is an aspect which is characteristic of customary rules in general. It's just that they become particularly obvious when you're talking about rules of recognition. And finally, just to say that what all this has to do with precedent, which I've talked a little bit less about here, despite it being really the core focus of the paper, which was written for a collection on philosophical foundations of precedent, is that when you have these precedents, individual precedents, which speak to the content of rules of recognition, and you have both the doctrine of precedent, which overlays this sort of rule upon a practice, customary practice of precedent, then you have regularly these opportunities for the courts, who are indeed empowered and required, to continually reflect and then either reaffirm a rule of recognition or reform a rule of recognition, or indeed reformulate it in such ways that it then gets carried on through other aspects of the diffuse official community. So precedent has a provocative effect, but individual precedents can not only be avoided as per the rule of precedent or the rules and doctrines of precedent, but there is also this underlying avenue through which courts can escape precedent when they engage in this reflective way of developing the rule of recognition.